We are on the record in Douglas County Superior Court. It is July 21, 2022. We're here in Adams versus Confluence Health. This is cause number 22-2-00104-09. This hearing is being conducted via Zoom. I've asked Madam Clerk to keep everybody muted. We're going to unmute the attorneys, Mr. Lacey and Mr. James. Madam Clerk, if you wouldn't mind unmuting the attorneys. There's Mr. James is unmuted. And Mr. James, let me inquire, it's your client's motion. Will there be any other attorneys besides yourself making presentations today?
No, Your Honor, just myself.
All right. And same question, Mr. Lacey, are you the only attorney arguing for your clients?
Yes, Your Honor.
All right, very good. Then what we'll do, let me make sure I understand. On behalf of the defendants, we of course have the motion to strike the declaration of the plaintiff's expert. We have the motion to dismiss. On the plaintiff's side, we have the motion for sanctions. Hopefully that's all the court's being asked to decide at this time, and those are all of the issues the court will hear argument on today, correct?
That is correct, Your Honor.
I agree.
Okay, very good. Then what we'll do is I'll hear from, what I would ask counsel to do just for organizational purposes, I'll hear from Mr. James, and I'd ask Mr. James to address, whatever matters he wishes to address. And then I'll hear from Mr. Lacey, and he'll make his presentation for the plaintiffs, and then I'll hear from Mr. James again. So in other words, we're not going to parse out the different motions. I'll just hear from you all in one big lump, if you don't mind. So with that, we'll mute Mr. Lacey. And Mr. Lacey, if you should want to say anything if there's an objection or some such thing during Mr. James' presentation, feel free to raise your hand or send a message or something, and otherwise make it known. We'll make it known, and we'll try and keep an eye out for that. For now, Mr. James, you have the floor.
Thank you, Your Honor, and good morning. I represent Confluence Health, Wenatchee Valley Hospital and Clinics, and Central Washington Hospital and Clinics. And I'm first going to address the pending motion to dismiss, which is based on the fact the plaintiffs have failed to state any claim in their amended complaint upon which relief can be granted. They have actually pled two causes of action, one for wrongful discharge in violation of public policy, and another based on perceived disability, failure to accommodate that perceived disability, and engaging in disparate treatment based on that perceived disability. So I would like to start with the wrongful discharge cause of action and address those arguments. And then I will move on to the others, and I will finally wrap up with the arguments in support of the motion to strike. This matter has been fully briefed, so I'm assuming the court is aware of our arguments. I will try not to repeat everything that is in the briefs, but at any time, if the court has a question, I would respectfully ask that the court ask it so that I can make sure the court is understanding our position. With respect to the wrongful discharge in violation of public policy, as the court is aware, there has to be a clear mandate of public policy to override what in Washington is the default standard of employment at will. And the plaintiffs have cited to three legal bases on which they base their claim. The first is a statute, RCW 4970-122.010, which is referred to sometimes as the Patients' Rights Statute. This statute provides that patients have a fundamental right to control the decisions relating to the rendering of their own health care. It is somewhat ironic that the plaintiffs attempt to rely on this statute, because here it is not patients that are asserting a right, but rather it is the healthcare providers that are asserting that they have the right not to be vaccinated and yet provide direct patient care. We submit that RCW 4970-122.010 clearly does not establish a clear mandate of public policy supporting a claim for wrongful discharge. Next, they cite to Article 1, Section 7 of the Washington Constitution, which provides that no person shall be disturbed in his private affairs or his home invaded without authority of law. This is the Search and Seizure Act that applies to state action. It's hard to see how this could possibly be applicable here, but we don't need to strain to figure out the plaintiff's thinking, because we know as a matter of law that Article 1, Section 7 applies only to state action. That was made clear in Trumbauer v. Group Health Hospital. And there has been no allegation pled that any of the defendants are state actors, and in fact, they are not. That leaves us with their third cause of action, or third cited legal basis for finding a clear mandate of public policy, which is the case McNabb versus Department of Corrections. This again involves Article 1, Section 7. At issue there was a prisoner's right to refuse force feeding by the state. Again, this is state action involving Article 1, Section 7. It clearly does not apply here. No one has tried to force anything upon the plaintiffs, let alone the defendants here. And again, ironically, in that case, the Supreme Court held that the state's right and its interests outweigh the individual interests of the prisoner. So because there is not any clear mandate of public policy, then under Washington jurisprudence, the plaintiffs have failed to state a claim, and that claim should be dismissed. But we can go even deeper into the analysis and look at why their claim is clearly lacking under the 4 elements that were identified as the Parrott test. And this is an area where we disagree with plaintiffs. We believe that because there is no clear mandate of public policy, that the 4 Parrott elements do apply even under the most recent discussions by the Washington State Supreme Court. I've just discussed how they cannot possibly satisfy the clarity element because there is no clear mandate of public policy. Regarding the jeopardy element, I think it's apparent that the plaintiffs here are acting in their personal interests and not in furtherance of the public good. There has been a fair amount of briefing back and forth about the policies set forth in Governor Inslee's proclamations and the recitations in those proclamations about the need to vaccinate as many members of the public as possible to protect vulnerable adults, children, patients, etc. So that public policy there is very clear, and there is no indication whatsoever that the plaintiffs are acting to further that public policy. On the contrary, they are acting out of their own personal self-interest to avoid being vaccinated and still claiming that they should be allowed to provide direct patient care. So with respect to the jeopardy element, their claim clearly fails. And getting to the 4th element, which is whether the employer has an overriding justification for his actions, I believe in this case, Your Honor, the court can take judicial notice of the fact that there's a pandemic currently sweeping the globe. That pandemic was in effect at the time of these actions. The governor's proclamation lists in great detail the science that was reviewed to support the vaccination mandate and the medical authority that supported that. The governor's proclamation clearly states that a healthcare provider shall not allow, the operator of a healthcare setting shall not allow a healthcare provider to work in a healthcare setting. Now, it does provide 2 exemptions, but it does not state that exempt employees shall be allowed to provide patient care, direct patient care. And in fact, we have provided, well, I'll just leave it at that because I don't want to introduce extraneous evidence into a motion to dismiss. But the policy pronouncements in the proclamations certainly provide an overriding justification for the operator of a healthcare setting to make decisions to remove persons from providing direct patient care, which is what the defendants did in this case. Now, we're not arguing that the plaintiffs did not have the right to decline being vaccinated. No one has ever said that. But as the US Supreme Court noted in Jacobson, that right is not absolute, and it does not grant them any particular employment rights. For example, they couldn't bring a gun to work, but they have the right to bear arms. They couldn't smoke pot at work, but they have the right to legally use marijuana in this state. They wouldn't suggest for a moment that they have the right to take care of patients when intoxicated by alcohol, but they have the right to consume alcohol. In fact, there are a host of things that an individual can't do at work that the individual has the right to do on their own time. But that does not mean that their declining the vaccine gives them any claim for wrongful discharge in violation of public policy or modifies the employer's ability to discharge their at-will employment. So for all of those reasons, and for the reasons set forth in our opening brief and our reply brief, we respectfully request that the wrongful discharge claim be dismissed because they have failed to state a claim under 12b-6. Does the court have any questions with respect to that cause of action? If not, I will move on to the disability discrimination claim.
Thank you. No questions.
Okay. So this claim is obviously flawed as a matter of law based on Washington jurisprudence and RCW 4960. Here, the plaintiffs are claiming that they were discriminated against based on a perceived disability. But in order to state a claim for perceived disability, they in fact have to have been allegedly discriminated against based on a disability that doesn't exist, but is in fact a disability. And that's where their claim falls short. The courts and the Human Rights Commission use the term impairment to discuss a disability. And in the Taylor versus Burlington Northern Railroad Holdings case, our Supreme Court went to great lengths to establish what an impairment is as opposed to an ordinary condition that individuals may experience, such as being overweight is not an impairment. Obesity is an impairment. Here, the only thing that the plaintiff's amended complaint identifies is that they have the status of being unvaccinated. And respectfully, that doesn't cut it. Every human being had this status until recently, and many still do. But an impairment, as the Washington State Supreme Court made clear, and as the Washington State Human Rights Commission has made clear, an impairment is an abnormality. By definition, it's not a normal condition. So because the plaintiffs have not alleged that they were discriminated against based on a perceived impairment, they have failed to state a claim for perceived disability discrimination, and that claim should be dismissed. Further, there can't possibly be a claim for failure to accommodate a perceived disability. I mean, it's logically nonsensical that you could accommodate something that doesn't exist. But regardless of that, the Supreme Court in Taylor stated unambiguously, quote, "But in a reasonable accommodation case, the employee must show that they are actually suffering from an impairment, not that they're perceived to suffer from an impairment." That was exactly what the court was addressing. They have to show they're actually suffering. Here, the plaintiffs have failed to plead that, and therefore that claim must be dismissed. They also claim that they were subject to disparate treatment. And in this regard, Your Honor, based on their complaint, they can't possibly state a claim, not only for the reasons I just mentioned, but because they acknowledge that every single employee of the defendants was subject to the same vaccine mandate unless they could qualify for an exemption. So there was no disparate treatment, it was uniform treatment, and that's another reason why they failed to state a claim for which relief can be granted. Lastly, excuse me, In their original caption and in their statement of causes of action, they included the words disparate impact. And that is a completely separate type of disability or discriminatory analysis, where you have to have a policy that is facially neutral, but its application falls more heavily on a protected class. They have failed to allege any of those elements. They did not respond to our arguments in our motion that they had failed to do so. We are assuming that the disparate impact language was inserted by error, but if there is any further argument on that, I would appreciate the opportunity to address it in rebuttal. For all of those reasons, the claim for perceived disability discrimination, failure to accommodate, and disparate treatment fail as a matter of law and should be dismissed. Now, before ending my arguments with respect to the causes of action, I would appreciate the opportunity to address the claim that has not been pled, and that is a claim for medical or religious-based failure to accommodate. There seems to be some suggestion in the response.
Hold on, Mr. James. Mr. Lacey wants to say something. Madam Clerk, if we could unmute Mr. Lacey. Was there an objection? Yeah, we're in the process of unmuting Mr. Lacey. And Mr. Lacey, I think you're going to need to hit your unmute button as well.
Let's do it. There we go. You hear me now? You're on.
Yeah, go ahead.
I'm arguing unpled claims. I agree that I didn't plead a claims beyond what are stated in the complaint. In fact, I even agree that to the extent he perceives there was a disparate impact claim pled, it wasn't intended. But certainly there was no claims being pled with respect to disability discrimination beyond that or any other claims. This is a 12B6 motion, and if in fact the court doesn't completely dismiss the case, after discovery, I'd have an opportunity to amend. And I don't want counsel arguing cases that aren't pled, so that then he'd have the argument later, well, gee, you can't amend your complaint. The court's already ruled on that during a 12B6 motion. We haven't had any discovery in this case. So I object to him going on and arguing matters that are not in the record.
All right, Mr. Lacey, I want to clarify. So I'm looking at the amended complaint toward the bottom of page 5. It alleges violation of RCW 49.60.180, perceived disability discrimination. Then in parentheses, it reads both disparate treatment and failure to accommodate. And what I'm hearing you say, Mr. Lacey, is that the disparate treatment claim, to the extent it was pled by mistake and
No.
it's withdrawn. No,
Your Honor. With all due respect, I think you're confusing potential claims. I did intend to not plead a disparate impact claim. A disparate treatment claim is different than a disparate impact claim.
Right.
So
I heard you
pleading that I did not intend to say that their actions had a disparate impact on other people and therefore were unconstitutional in some kind of equal protection or some kind of other argument. I am claiming a disparate treatment claim that they were fired and that we can meet the terms of that. I'll get into that later. Right now, he says he wants to go on and argue some things that weren't pled and basically take care of them. And I'm saying if they aren't pled, there should be no argument about them right now. If he wants to argue disparate impact, he doesn't need to, because I didn't plead that. But I think he wants to go beyond disparate impact and argue some other claim. And I forget now exactly what was stated, but that's my argument.
All right, thank you very much. Mr. James, I tend to agree in this 12B6 motion, we probably don't need to argue unpled claims. We need to deal with the pleadings as currently framed. I don't begrudge that you want to argue, across the board, but anything that you think perhaps the court hasn't considered?
Well, Your Honor, I wanted to make sure that those, claims were not pled. And given Mr. Lacey's concessions that he's not pleading disparate impact or failure to accommodate based on medical or religious disability, then I don't need to argue those other than to say one thing, and that is, if and when the court is considering whether to allow leave to amend, we would like to be heard on that, because certainly Mr. Lacey has had every opportunity to plead those claims, and several, I think as many as 10 of the plaintiffs have those types of claims pending before the EEOC. So we would argue res judicata or some other legal doctrine bars him from raising those claims after this point. But I will save those arguments for when the court is prepared to hear them. And I will, unless the court has any questions about the claims that were pled, I will move on to the motion to strike.
All right. Mr. Lacey, Mr. Lacey, I think you're unmuted.
Okay. Basically, now we're on the other side of the coin, and that is that he would like to use my objection to his arguing things that are not currently in the pleadings as a bar to my being able to amend my complaint sometime down the road. And I think that's improper. So if you think that there's a chance,
this court's not going to bar anything today. We're just ruling on the motions that have been framed. So
all right,
I think
I'm not intending. If he wants to argue failure to accommodate actual religious or medical disability claims, and he wants to argue why that couldn't possibly be judicially cognizable, let's go ahead and let him, because I'm not representing that down the road I would not amend the complaint to include those claims if I thought it to be appropriate. I just haven't done the discovery yet.
All right, fair enough. Mr. James, are you satisfied that you've sufficiently addressed the pled claims?
I am, Your Honor. Thank you very much.
All right, let's go ahead and move on to the next issue.
All right. Defendants have also brought a motion to strike the declaration of Dr. McCullough. Again, this is fully briefed, but there are a few other things I would like to add in support of the motion. We have brought to the court's attention the case of Jacobson, and despite the fact that it was decided almost 120 years ago, it is good law. It's been cited by the current U.S. Supreme Court as well as Chief Judge Rice of the Eastern District of Washington recently. So I don't think there's any flaw with the analysis based on the fact that it was an older case. Just the opposite. These are timeless bits of information that the courts have passed down, and there's no question that it is up to the legislature to set policy with respect to public health issues, not the courts or the juries. And in this case, while Dr. McCullough holds himself out as a qualified medical expert in public health to give testimony, that testimony should have been given to the governor or the legislature of the state of Washington. It has no place in this case because we're not here to argue the science. The governor and his advisors, public health officials, made the determination, and now that is the law of the land. And to argue contrary to the law of the land and to argue that it should be disregarded in favor of voluntary vaccinations when the law is that these are mandatory unless exempt, and to argue that the science should be different, it's irrelevant and it's impertinent. And frankly, I think it's scandalous. And that's not a word I use often, Your Honor, but it is one of the terms used in Rule 12F. And as an example of how it's scandalous, I noticed in rereading the declaration a particular allegation on paragraph 2, where Dr. McCullough opines, stating his, quote, belief within a reasonable degree of medical certainty that the COVID-19 vaccinations are not safe generally. It is my belief that on a reasonable degree of medical certainty that the vaccine could cause the death of a significant number of the plaintiffs. Now, I find that statement to be extremely scandalous. there were thousands upon thousands of dedicated Confluence employees who got vaccinated. To my knowledge, not a single one died. And here this doctor is offering to the court his medical opinion with reasonable medical certainty that a significant number of the 90.
Hold on, I'm sorry, Mr. James. Go ahead. Did you have an objection, Mr. Lacy?
Yes, Your Honor. With all due respect to counsel, I thought we were arguing a 12B6 motion here, or that we were dealing with things that are in the pleadings and the implications of what has been pled. He's arguing a factual issue that I certainly personally disagree with, and trying to establish it as a matter of factual justification for what they did, and that therefore we can't counter it. If he wants to argue that on summary judgment after we have some evidence in the record as to whether or not these vaccinations are actually safe and effective, that'd be great. But now he just wants you to accept whatever political pronouncement was made by the governor as true, and then say that that somebody's disagreement with that is scandalous. We aren't there yet in this country, where if you disagree with the government's decision, that's a scandalous act. We shouldn't even be dealing with that here today.
The word scandalous does appear in the case law as a relevant factor for the court to consider. Mr. James, what's your response to the objection that I'm hearing from Mr. Lacy?
I think Mr. Lacy misunderstood. I'm not offering this with respect to the 12B6 motion. We're here to argue more than one motion. And I had told the court I was turning to the motion to strike. And perhaps Mr. Lacy didn't catch that. So
it does raise the question, though, if it's a 12B6 motion and the court's not supposed to consider evidence outside the pleadings, do we need to talk about declarations that may be on file that apparently the defense's motion seeks that the court should not consider?
Well, Your Honor, we did bring two separate motions, and I am compartmentalizing. I am not saying that the court should consider these arguments when evaluating the complaint under 12B6. We brought a separate motion to strike the declaration of Dr. McCullough under 12F. And my understanding of the rules was that we had to bring the motion under 12F before pleading further. So that's why it's pending as a separate motion.
Is the state, or excuse me, is Confluence Health seeking for the court to consider the declaration of Dr. Scott Lindquist?
Only to the extent necessary for the motion to strike.
Okay, that's helpful. Thank you. All right, I'm going to overrule the objection for now. We are talking about a separate motion to strike. So please continue, Mr. James.
Well, Your Honor, it is a scandalous statement. Fortunately, it's not true. Thousands of Confluence employees have been vaccinated without anyone dying. But sadly, in Chelan, Douglas, and Grant counties, according to the Department of Health's dashboard yesterday, there have been 466 deaths from COVID. Now, to argue an opinion against the rule of law, against the medical science that has been accepted by the legislature, is something that the Supreme Court in Jacobson said is not anything that the court should consider, because that ship has sailed. Medical science was presented, the elected officials decided which science to adhere to, and that is the end of the analysis, unless the plaintiffs or whomever wants to go to Olympia and challenge things with the legislature or the governor. So we submit that the test for striking the declaration under 12BF is clearly met, and Dr. McCullough's declaration should be stricken. And Your Honor, that concludes my arguments in support of the motion under 12BF.
All right, anything else before I hear from Mr. Lacy?
No, Your Honor. Thank you.
Thank you very much, Mr. James. Mr. Lacy, you have the floor.
Thank you, Your Honor. Well, as I've stated before, and we'll reiterate, this is a 12B6 motion, and a lot of what I read in the briefing by the defendants in this case were factual arguments that I'm going to frankly modify my response about, because they haven't made many of those factual arguments today in their oral argument. So let me just start out by saying this, that much of the briefing that I have seen from the defendants has seemed to focus on the fact that they felt that Confluence takes the position that they were compelled by the proclamation of Governor Inslee to take the actions that they did, up to and including discharging my clients. And although the briefing's a little convoluted at this point on the issue, originally they seemed to concede in their briefing, and I believe they are conceding for purposes of this motion, that all of my clients have been fired, either constructively or expressly. And therefore, there is no one that's a party to this action right now who would not be able to claim a discharge, subject to discovery and the ferreting out of whether or not they were either expressly or constructively discharged. Now, having said that, the court should not lose sight of the standard that the court has to deal with in a 12B6 motion, which is heavily weighted in favor of the complaining party. In fact, if I might, Your Honor, the Tenor case, which I cited, indicated that a dismissal under this rule involves, quote, a question of law which is reviewed de novo by an appellate court and is appropriate only if it appears beyond doubt that the plaintiff cannot prove any set of facts which would justify recovery. In such a case, a plaintiff's allegations are presumed to be true, and a court may consider hypothetical facts not included in the record, which is why, of course, I objected when he started arguing and stating facts that I believe would not ultimately be proven true, such as that COVID vaccines, as he calls them vaccines, are all safe and effective. I don't think that's been decided in this case, or in any case in this, even though there may have been some political decisions made along the way based upon that alleged justification. But back to the point, CR 12B6 motions should be granted sparingly and with care, and only in the unusual case in which plaintiff includes allegations that show on the face of the complaint that there is some insuperable bar to relief. So then the question becomes, I submit to the court, what insuperable bars to relief have they really persuaded the court, or can they really persuade the court exist in this case right now, based on these pleadings? Well, as I hear him arguing for the defendants, he's saying that the first insuperable bar would be whether the issue of whether or not a claim can be stated based upon a public policy as addressed in the complaint of a person's right to make their own unfettered healthcare decisions themselves, as opposed to having the government or somebody else tell them how and what they should do in terms of making them. And his argument, as I'm hearing it, is that he believes the statute makes a distinction between patients and individuals, and that therefore that statute is just a patient's rights statute and doesn't apply to individuals. However, the statute itself speaks in terms of adult persons. It doesn't say anything about patients at all. And the case on which I rely, the McDabb case, that person wasn't a patient. He was someone who wanted to take his own life. And the only treatment he got as a patient was forced treatment. So clearly it applied to him, and that case applied it to him. My clients are adult persons. They fit under the terms of the statute. That argument makes no sense from an insuperable bar position. He next argued that the constitutional right established by Section 1, Article 7 of the Constitution, which includes, by pronouncement of our Supreme Court, the fundamental right to make one's own healthcare decisions, and not be used in a public policy case against a private actor. He cites absolutely no, there's no argument supported by any authority anywhere in their brief that indicates that you can't use a constitutional right as a clear public policy in this state. In fact, the cases are replete in situations where people have sued successfully against private actors because the private actors usurp many of their constitutional rights. One that comes right to mind is the freedom of speech, the right to speak out on a matter of public concern. There have been numerous employers in the state of Washington that have been held liable on a wrongful violation of public policy discharge basis for firing people when they spoke out on matters of public concern, even though they were not state actors, even though they were private employers. And there's nothing in the case law under Peel or even going back to Thompson or any of those cases that indicate that you can't use a constitutional right that applies to the government as a basis for public policy. And in this case, we have every right to. Thompson was a federal statute. It created a federal right. The very first case in this whole line of cases involved a federal right, a statutory right, established by the Congress. So there is no basis for saying here that there's no valid public policy upon which to base this claim. Notably, and again, I spent a fair amount of time in briefing this case, trying to disabuse them and the court of the idea that my clients were barred from bringing a claim against Confluence Health by virtue of the language of the proclamation itself, and by virtue of their argument that doing so is tantamount to saying that employers didn't have to follow the law. Remember, that was their argument in their original briefing. In fact, that was the argument they made initially for wanting to strike Dr. McCullough's declaration, was that he was tacitly saying, by challenging the medical views of the establishment here in Washington, that in fact these people should not have followed the law. But as I pointed out, and they apparently have conceded now looking at their reply brief, there's nothing in that proclamation that suggests that exempt unvaccinated people have to follow the same rules that non-exempt unvaccinated people have to follow. Now that's very clear in the proclamation. In fact, after setting forth, and I gave the court a copy of it, after setting forth the requirements on healthcare providers and people who employ healthcare providers, the proclamation then has a whole section on people who are and basically establishing a mandate for people that did not take this jab. The proclamation goes on and basically indicates who is exempt from this mandate. It says right in the heading, exemptions from vaccine mandate, right? They go on in their briefing and argue that, well, impliedly what this means is that Confluence Health was justified in terminating anybody who didn't get the jab, even though they hadn't a valid exemption or may have had a valid exemption. And their reasoning for that is that it's in the public's interest of public health to terminate people so that they won't be engaging in direct patient care. But that's not an idea that originated in that proclamation. And when we get into discovering this case, we might find out where that idea originated. But it didn't come from the governor's proclamation. And it didn't come from the Department of Health. And I invited them in all candor in my responsive brief to come forward with anything specific from the Department of Health that would clarify what the proclamation did say about that. The proclamation said that people who were granted exemptions, admittedly, Governor Inslee went to great lengths to try to convince employers to be strict about granting exemptions to people because he was afraid that the exceptions might overwhelm his rule. But not once did in that proclamation did it say, oh, by the way, if you grant an exemption, you must bar these people from direct patient care. Instead, it said, if you grant an exemption, you must make sure that you follow the recommendations of the Department of Health thereafter with respect to those employees. Well, in their original brief, they did not specify anything from the Department of Health that basically barred anybody from direct patient care. And then after I gave them my responsive brief and gave it to the court, they still haven't provided anything from the Department of Health that would indicate that impliedly, based on the Department of Health regulations, that there was a mandate in this proclamation to terminate people if they would otherwise be involved in direct patient care. That's an argument that's coming out of thin air here. Again, in discovery, we may find out just where it's coming from. I got a hint in the response to the motion for sanctions when he provided a letter, which frankly, I wondered what had to do with the case, but he provided a letter impliedly it was emailed to Peter Rutherford, wherein some policy analyst in the local Washington State Human Rights Commission took that view that you couldn't allow these people who once they were qualified for an exemption under the mandate to engage in direct patient care. But there was nothing to back that up. And she even said in the letter, she wasn't guaranteeing that it wouldn't get them a lawsuit. So again, no basis for dismissing a case on that ground. And now they seem to have abandoned it. So their next argument is, moving on, is the Pareto analysis. And they go to the original analysis under the Thompson line of cases, which have been clarified many, many times. And his argument basically sounds like an argument I used to hear in court before the court came down with the Peel case and all the subsequent cases that dealt with and refined the analysis under wrongful discharge in violation of public policy, much of which is no longer the law. But what we do know now, and I've cited the case law in my brief, what we do know is that if you allege a hybrid case, meaning constructive discharge in violation of public policy, or even if you don't, the only issue for the court is whether or not a public policy may have been contravened by the action of the employer, and whether or not the employer essentially has an overriding justification for having taken an action which may have contravened the public policy. And that's basically the gist of the case. And there is no real jeopardy analysis anymore. There hasn't been since Rose and Peel and all the cases that overruled McCarty in the Supreme Court. And so his argument about jeopardy analysis and the fact that my clients are somehow serving their individual interests and not serving the public interest is just not being heard anymore. You can serve both. You can serve your interest and you can serve the public interest at the same time. And that's why these private attorney general type of causes of actions are there, so that you can do both. And my clients clearly are doing both. Next, his argument, again, he's still trying to establish an insuperable bar to relief against these claims, which, by the way, are well-established claims in the state of Washington. discharge in violation of public policy, disparate treatment, disability discrimination, and even failure to accommodate. There's been hundreds, if not thousands, of cases in the courts on all of those claims, on all of those causes of action. We're not trying to allege causes of action here that are new or novel, or that have some insuperable bar to relief. For example, in the, I think it's the Markov case, that was the firefighters case, if I'm getting those two, not getting those two mixed up. There was an insuperable bar to relief because the firefighters were arguing that they should get damages for having been harmed in a gas fire that they responded to as rescuers, and the rescue doctrine provided an insuperable bar to their relief. There was no set of facts that they could prove that would justify bringing a case for negligence based on their injury, because they were barred, completely barred from bringing those kinds of claims by that doctrine. But they haven't brought any of those types of arguments here to you. They have simply said, you know, we want you to find that the patient, that the parties that have sued here haven't met the clarity issue. They haven't established a public policy, a broad public policy that can be upheld. Well, we have. They want to, then they get to the overriding justification. And as I hear the argument made by counsel, with all due respect, he's asking you to decide that factual issue as a matter of law on 12b-6. He's suggesting to you that they had such an overriding justification for doing this because, after all, they had a mandate, which, by the way, they admit now impliedly didn't require them to fire anybody, but they were still overridingly justified in doing so. But by the way, they say, you should find, Your Honor, that we were overridingly justified in doing so, but don't let Mr. Lacey or the plaintiffs examine any of the facts that go into that overriding justification. And in fact, we'd like you to strike Dr. McCullough's declaration because he contradicts some of the so-called science that the state relied upon to issue that proclamation. Well, my argument again is twofold. Number one, we're not challenging the governor's actions or the legislature's actions. I could, I mean, I would love to, because I personally believe that the governor didn't have that kind of delegated authority, but let's assume he did. And I personally think if he did have it, the legislature probably overreached in terms of giving him authority well beyond their power to delegate, which they may have done, but we don't care. And we don't care whether or not Jacobson is correct. You know, Jacobson was a case, since he mentioned it, which was decided on a standard vaccine for, I think it was smallpox. That was a vaccine, what we really call a vaccine. What we have today are some therapeutic agents created by a company given blanket immunity by the government to go in and create an agent which will go in and tell the body to create a pathogen, the very pathogen that constitutes the COVID-19 virus. It's the spike protein. And every cell in the body then would be required to produce or forced to produce spike proteins. So presumably we'd get some kind of immune response from the body. I'm not setting myself up as an expert on that. I'm just telling that there's an argument, which I wanted to make it, for the fact that these really aren't effectively vaccines, and that Jacobson did not deal with a vaccine, anything like what Pfizer and Moderna and those people are capable of producing today, or that have the effect. But there is one issue there. It's clear that vaccines for smallpox and measles and those kinds of things that were created in the past, if you took that vaccine, you could be assured that you weren't going to get the smallpox or the measles. But if you take one of these so-called vaccines, you can still get the smallpox and measles. Science is getting really, really adept at understanding that. You just might have a slighter chance of being killed by it. So is it a vaccine? I don't know, but I'm not here to argue that today because I'm not challenging President or Governor Inslee or anything that he did. I made politically disagree with it. But the real question is, did that justify Confluence in terminating my clients? And I suggest to you that we're going to have to see some discovery to figure that out. And all that comes back to this overriding justification. One thing I didn't hear counsel argue today, but she argued extensively in his brief, was about natural immunity. He said, well, you know, really what the plaintiffs are trying to do is force your hand or force the court's hand, or to argue that that Confluence should have considered in determining whether to follow the mandate or not this issue of natural immunity. And I'm not saying that. I never pled that, nor have I argued that. I'm saying that once they reached a point where they had to make their own decision about whether or not, or how to deal with how they accommodated these employees who had spent a year and a half working directly with COVID patients. Once they reached the point where they had to decide how they were going to handle the accommodation for those people, they had a choice to make. And that choice, and they knew it, was being made differently by other entities. And they actually told their employees that. Other entities, including healthcare entities in our own region, had decided to approach accommodation of these workers who were not going to get so-called vaccinated by basically applying the standards of which the Department of Health actually did mandate. And they did so, but Confluence didn't want to do that. They were getting some advice, apparently, now that we've kind of gotten into some of the facts through the presentment by the defendant. They wanted to take some advice from Governor Inslee's administration, the policy analyst at the Washington Human Rights Commission. Apparently, that's what they wanted to do. So they decided that when they did this analysis of how to approach this, that they would make the decision based on whatever advice they had and information they had, which we still don't know for sure. We haven't done all the discovery, that they were going to take a blanket position that anybody who got an exemption, even though they were exempt on the face of the proclamation from the vaccine mandate, would still lose their jobs. It would be taken out of patient care. Now, their argument is, well, they weren't fired. Well, some of them, they all were fired. Again, I think for purposes of the 12b-6, they have to concede that. But in reality, not a single one of these 92 people that I represent are working at Confluent Health today. So the argument that they're still employed is a red herring. They're not employed. Some of them are union workers who still have grievance pending, and so they haven't formalized their terminations. But they are not working for Confluence Health, and as a practical matter, they're all terminated. So then the question comes back to overriding justification. That's where things like natural immunity come into play. Because if science did recognize, and also will recognize, that people who have had COVID-19 or been exposed through long periods of work to COVID-19 are unlikely to get it or have a severe case of it or be able to transmit it, then you could take that into account when you decide what accommodation you're going to get. And the argument that, well, we couldn't put them back in direct patient care is at worst disputed in this case. They simply haven't cited to anything that would make it an insuperable bar to relief to suggest that these people should have been left on their jobs. And it is their burden, because they have to provide the overriding justification. It's an affirmative defense under these cases, under all of these causes of action. It's their burden ultimately to show they were justified in the action that they took. And they don't want you to allow me and my clients to explore that justification in any significant degree. They want you to say right now, without a bit of discovery, without a bit of investigation, that we can't even go forward and discover the facts as to what really underlie underlays their claim that they were overridingly justified in what they did. And that's not the purpose of a 12b6 motion. Now, as to the disability claim, again, disability claims for disparate treatment or can be based on a perceived disability. I cited that case law in my brief. They claim there was no impairment. I'm saying there was an impairment. It depends upon, and that's why the case law is replete with statements about this. These cases are difficult because you don't know what the employer was thinking, which again is a great reason to do discovery, to find out what the intent of the employer was and what they knew. But what this employer apparently seems to have been thinking was that if you didn't have a vaccine, that you could transmit the virus, or you were more prone to transmit this virus than somebody that did have what they called the vaccine. And therefore, we have to exclude these people from the workplace because their bodily systems are in such a state that they're more likely to be a risk to others in the workplace than the people that we are going to still employ, who, by the way, 5 or 6 months ago completed their course of vaccines. They only required the first 2. Now we know, and they should have known in October of 2018, that by October 18th of 2018, which was their drop dead deadline, that anybody who got 2 Pfizer vaccines or 2 Moderna vaccines or 1 Johnson & Johnson vaccine no longer had any significant protection from those vaccines 4 to 5 to 6 months later. So there's no distinction. When we get into discovery, we're going to find this out. There's no distinction to have been made between someone who got those 2 vaccines in the spring of 2021 and someone who didn't. By the time you got to October of 2021, once again, the science is going to show, if we can do discovery, that there was no distinction to be made. So why fire the people that didn't take those 2 shots and keep the people that did? These are the issues that have to be explored in discovery when it comes down to overriding justification, and not the question of whether or not they did what the government told them to do in their view. They made an interpretation on what the government was telling them to do in their view, and no one can question it. So when it comes to the disability discrimination claim, yes, my people did have an impairment as the case law defines it. And if they were fired because of that, that's disparate treatment. I'm not making a disparate impact claim. And frankly, although I don't know how the discovery is going to come out, I'm kind of persuaded that the failure to accommodate claim is not going to fly either. Although I don't know enough about it to simply say at this point, because I've read one case, that you ought to just dump that claim. And there's still an opportunity for counsel to bring a summary judgment after we get the facts in this case. And maybe that failure to accommodate claim doesn't lie. So I'm not going to be disingenuous with the court. I think he might have a pretty good argument on that. But as to dismissing this case because of an insuperable bar to relief, when I can rely on hypothetical facts and state them all day long, and he has to accept them as true, and so do you, that's just not in the cards here. That's my argument.
Okay, thank you. Mr. James, your client brought the motion to dismiss. You get the last word by way of rebuttal.
Thank you, Your Honor. I respect that Mr. Lacey feels strongly about these issues and has the right to his personal opinions, but respectfully, that has nothing to do with the motion to dismiss. I did not hear him argue how he had pled things specifically focusing on his complaint. I did not hear him state the set of facts under which he could survive a motion to dismiss. His complaint identifies 3 items for the public policy claim. This is not a situation where the individuals are claiming that anybody interfered with their patient rights. They are the caregivers. The argument that the vaccine is safe and effective, I'm not making that argument, sir. That's straight from the proclamation where the governor declares in the recitations that this is a remarkable vaccine that is safe and effective. So if the governor was wrong, if the science was wrong, it still is the current law, and that's what's in the proclamation. But to say that we didn't cite to anything requiring that Article 1, Section 7 be based on state action is it's incorrect. We cited twice in our brief to the Trumbauer decision on page 7 of our opening brief and on page 8 of our reply brief. And in that case, it's rather clear that this type of claim cannot be based on Article 1, Section 7. The court wrote on page 549, Trumbauer asserts, in order to establish a termination in violation of public policy, Trumbauer must first identify a stated public policy, either legislatively or judicially recognized, that may have been violated. And the court cites Thompson, as Mr. Lacey did. Court goes on to say Trumbauer asserts claims under 3 provisions of the Washington State Constitution: Article 1, Section 3, the due process provision; Article 1, Section 5, the free speech guarantee; and Article 1, Section 7, the search and seizure provision, just as the plaintiffs are. Court then says, quote, the due process and search and seizure provisions of the Washington State Constitution apply only to state action. Trumbauer's claims under these provisions must be dismissed because Trumbauer's allegations present a purely private dispute. Although Trumbauer suggests that group health as a provider of medical care is regulated by the state, the circumstance is insufficient to establish that group health's actions constitute state action. There is clear and unmistakable authority establishing that this cannot support the claim that the plaintiffs have pled. Next, we went to lengths in our reply brief to point out that the plaintiffs have not pled that each individual is applied for an exemption and was either granted or denied an exemption, needed an accommodation, or any of the accommodation issues required by CR 8 to state a claim. So on its face, the complaint as pled by the plaintiffs reads as if they are simply not getting vaccinated. Now, the proclamation is very clear. And in fact, as Mr. Lacey pointed out, Governor Inslee came back and amended the proclamation to avoid any doubt. That proclamation, the amended proclamation 2114-1, says on page 5 that any healthcare provider is prohibited from working, from failing to be fully vaccinated against COVID-19 after October 18, and any operator of a healthcare setting is prohibited from permitting a healthcare provider to engage in work for the operator as an employee, contractor, or volunteer. I'm not making this up. This is right in the proclamation. There is no claim in the complaint that has pled. And by the way, it is the amended complaint. So we're talking about the second bite at the apple. There is no claim that can go forward based on the jeopardy argument or the overriding justification argument, because this law required the employer to do what it did with respect to non-exempt employees. Now, if they had pled a claim for failure to accommodate a religious belief or failure to accommodate an actual medical exemption, we would be having a different discussion, Your Honor. But they did not plead that, and that is why their claim needs to be tossed as a matter of law. We have not abandoned these arguments, as Mr. Lacey suggested. I was asked by the court not to get into them because they relate to religious and medical exemption. So Those arguments are still out there. I also just want to focus the court's attention, because there was a lot of discussion about science here, that what we're talking about is a short window in time. We're talking about the period when the Delta virus was spiking and people were dying and hospitals were overloaded. This is August and October of 2021. Whatever the science may show today, whatever the situation may be today, is not the information that either the governor or these defendants were dealing with back then. Lastly, with respect to the disability, it is his burden to plead the impairment. And all we heard him say is that these individuals were not vaccinated against COVID. What the employer was required to do under this mandate was to collect paperwork. It required them to collect proof of vaccination status from everybody. There was no disparate treatment. There was no impairment. There was a lack of proof of vaccination. And that does not state a claim under Washington law. Thank you, Your Honor.
Okay, thank you. I want to thank the attorneys for their quality presentations. It's certainly an interesting set of issues, to say the least. And I do plan to take this matter under advisement. And I'll go back into chambers, do some more legal research, and issue a letter ruling as soon as I can. And I'm unable to make any promises or guarantees about the timing of when the letter ruling will issue, but we will get it out as soon as reasonably possible. So thank you, everyone, for appearing in our court today. And with that, we will adjourn and go off the record. We'll see you soon.
Thank you, Your Honor.
Thank you, Your Honor.